Greetings and welcome to all who are joining this fourth session of Africa in the Moot's Open Access Education and Training Series for the 33rd Willem C. Vis Moot and the 23rd Vis East Moot competitions. My name is Erin Cronjé. I am a director of Africa in the Moot very, very proudly, and I am joined today by Warren de Waegh, who is a member of our Education and Training Committee. And for those who do not know, Africa in the Moot is a non-profit volunteer-based organization which supports sub-Saharan African teams to participate in the Vis Moot. And given that the Vis Moot is the world's largest commercial moot court competition, and there is of course an incredible educational experience afforded through this 8-month journey, we are very proud to host this open access session to support not only our teams in Africa in the Moot, of which there are 19 this year, but to also support all teams in their Vis Moot experience around the globe. So by this stage of the claimant's memo, I'm sure, and well, the legal research process as well, I'm sure that mooties may already be understanding, and if not yet, I'm sure your coaches will share their experiences and advice soon, that the Vis Moot brings to the fore very, very complex legal questions that have very real-world implications. And exemptions, particularly under Article 79 of the CISG, sits at one of the most complex intersections of the CISG. And that is where international uniform law sometimes meets quite unpredictable real-world events. Whether we call it force majeure or impediment or hardship, this provision raises real questions about risk allocation, foreseeability, and the limits of reasonableness of party control. So understanding Article 79 is not only an academic exercise, nothing ever really is, but it really does directly affect how we draft contracts, how we manage supply chains, and how we conduct cross-border litigation, and well, business, hopefully not litigation, although that sometimes is inevitable, and commercial relationships. And for many of you who are preparing for or supporting the Vis Moot, whether as coaches, arbitrators, or otherwise, Article 79 may be a familiar territory because it seems to appear every year, but because it also, when it does appear, it seems to be one of those most conceptually demanding concepts in the problem. So as we explore this doctrine today, I want all of those who are joining us, whether in the recording or live, to consider how would you argue these issues as counsel in your briefs, not only in your written briefs, but also in your oral arguments. How would you frame the burden of proof for certain of the components that come out of Article 79? And perhaps as an arbitrator, consider what would you expect from teams to address in their arguments to a tribunal on these issues. And of course, who better to lead you through this topic and this exploration than none other than Professor Ingeborg Schwenzer, who is a world-renowned expert on the issues. And Professor Schwenzer, who is a dear friend of Africa in the Moot, is a professor emerita of private law at the University of Basel in Switzerland and the former dean of the Swiss International Law School. Her CV is very, very long, very, very impressive. I think it's more interesting that we get to her presentation to the audience than for me to tell you every line and item of that. But what is most important, and what I hope will encourage you to be quoting her in your memos if you have not already done so, is that she has published numerous books and more than 200 articles on the fields of the law of obligations. So that's contract, tort, unjust enrichment, sales law, of course, both domestic and international, commercial arbitration, very importantly, and even family law. Very, very busy professor indeed. And in particular, she is one of the co-editors of the co-editor and one of the main contributors of the world's leading commentary on the CISG. And from 2011 to 2018, Professor Schwenzer was the chair of the CISG Advisory Council. In addition, she also has a very busy and active role in all areas of legal practice as an arbitrator, counsel, and legal expert in international disputes. So I had forewarned you that if you have not quoted already, I'm sure that you will be doing so shortly after this session, and I encourage you to do so. But with that, I stop talking, and I'm very eager and proud and privileged to hand over to our very, very special guest to take you through exemptions under the CISG. Professor Schwenzer, thank you so much, and the floor is yours.
Thank you very much, Erin, for this kind introduction. Good afternoon, good evening, ladies and gentlemen. It's a great honor and pleasure to be again here in the online session of Africa in the Moot. I think a very important initiative that has been launched and that is growing all the time. And so I'm happy to be part of it. And I wanted to congratulate all of you that you have decided to participate in the Vis Moot, which is going to be probably the best experience you will have throughout your whole law school studies. I will talk about exemption under the CISG tonight. And just for a short overview, I will start with a short introduction. Then we will have a look at Article 79. Then at the other provision that provides for an exemption, that is Article 80. And then I will very briefly compare mitigation of damages under Article 77 to exemption under Article 79 and 80, and finally come to a conclusion. So let me start with our introduction. The starting point of domestic legal systems with regard to liability schemes is very different. Under Anglo-American legal systems, we have a system of strict liability. If we go back in English law, strict liability was really very, very strict. And up to about 200 years ago, the debtor was not even exempted in cases of impossibility of performance. That changed a bit, so strict liability was getting less strict. And that is a very different starting point from the civil law legal systems. The civil law legal systems, going back to Roman law, are based on fault-based liability. That means the debtor who does not perform is liable in damages only if there was fault, some kind of negligence or other fault. So we have these poles, these two very, very different starting points. And as in many other areas, the CISG had to find a compromise, and it did so. It took as a starting point the Anglo-American system, namely strict liability. That means damages do not depend on any kind of fault by the non-performing debtor, but rather the debtor is strictly liable if there is any deficiency in the performance of the obligation. However, this strict liability is not as strict as in Anglo-American legal systems, but exemption is possible. And exemption is provided for in Article 79 CISG primarily, and Article 80 of the CISG, plus we do have the possibility of a mitigation of damages under Article 77. So if we look at Article 79, we start with Article 79.1, the basis for exemption, where it is mentioned that exemption is possible in case of an impediment beyond the control of the debtor that could not be foreseen and that could not have been avoided. We will discuss that in detail later on. Para 2 of Article 79 shows us when the debtor is liable for the acts or omissions by a third party. Para 3 provides for ongoing exemptions, and Para 4 contains a notice requirement, which I will also address later on because there has been questions asked regarding this notice requirement. And finally, we have paragraph 5 of Article 79 CISG dealing with the consequences of an exemption. So let's first have a look at Article 79, Para 1, the prerequisites for an exemption. The starting point is that we must have a breach of contract. And any breach of contract is possible under Article 79. It has been discussed whether non-conformity whether the liability for non-conformity of the goods may also lead to an exemption under Article 79. Especially American scholars are of the opinion that this should not be the case. You should never be exempted for any kind of non-conformity under Article 35. However, this is not important for this year's Moot case. So the starting point is there must be a breach of contract. And this breach of contract is not that easy to find because it may be the seller or the buyer. In case of a non-delivery of the goods, it would be a breach by the seller. And in case of a failure to take delivery, it would be a breach on the side of the buyer. So it is decisive, and that also relates to this year's Moot case. When does delivery occur? So that is the question. When does delivery occur? Who must procure the licenses that are necessary for delivery? Namely, export licenses on the one hand and import licenses on the other hand. And to decide when does delivery occur and what are the obligations of the parties, of the seller and the buyer relating to licenses for export and import, we must look at the relevant trade terms. And the parties usually they choose in their contract Incoterms. Nowadays, Incoterms 2020, the latest version of the Incoterms, and there we have different terms, and the different terms imply different obligations of the seller and the buyer. We have the D terms, for example, the delivery terms, where the seller undertakes more duties than under other terms, and where the seller has to deliver the goods to a certain place, very often to the buyer's place of business. And on the other side, we have the F terms, where it is the buyer who must secure import of the goods, including all the licenses. And if you look at Incoterms, probably you have already done so, you will find the respective duties of seller and buyers in A7 for the seller. What does the seller have to do in order that delivery is effected? And B7, what does the buyer has to do in order to take delivery by the seller? So this is the starting point from which you have to decide, well, did the seller or did the buyer at all breach the contract? Because if we do not have a breach of contract, then you don't have to discuss any exemption from liability for damages. Then there's no liability at all if there has been no breach. So if we look at the wording of Article 79, Para 1, we find, first of all, there must be an impediment beyond the control of the debtor. Typically, especially in civil law jurisdictions, we speak about force majeure, and under force majeure, we understand natural phenomena and catastrophes like earthquakes, typhoons, and the like that hinder the performance of the contract. It is disputed, and there will be a question to this effect also, whether state interventions in the French are speaking about fait du prince, that means acts by the prince, by the state, whether such state interventions may amount to an impediment beyond the control of the debtor. I think the prevailing opinion nowadays is positive. Yes, also state interventions are covered by Article 79. Although there are diverging opinions, there have been arbitral awards stating that state interventions are not are not an impediment beyond the control of the debtor. So, Article 79, like all provisions except for one, but all provisions of the CISG are not mandatory. That means it is primarily up to the parties to define or to define what are impediments beyond the control in their contract. And we do have contract clauses also in this case. In this moot problem, we have a contract clause dealing with impediments, with force majeure and the like, whereby the parties detail the prerequisites of an exemption under Article 79. It is, well, there will be a question that I might answer already now, and that is the relationship between such contract clauses and Article 79 CISG. Well, it's always there is always you always start with a contract. Yeah, and as there is Article 6 of the CISG, the parties are free to vary any provision and to derogate from any provision of the CISG. Thus, we primarily look into the contract. And if the parties in the contract, for example, specify what are impediments, whether state interventions amount to an impediment under Article 79, then their contract governs. Yeah, and then we don't have to rely on any different outcomes under Article 79 CISG. Thus, we primarily look into the contract, and only if we cannot find anything in the contract itself, then subsidiarily we go to Article 79 CISG. Article 79 not only covers what is called force majeure in civil law jurisdictions, it also, according to the now almost unanimous view, it also covers cases of hardship. That means where we don't have an impediment, like, for example, the goods are destroyed and cannot be delivered, but where it is possible to perform the contract, but the economic equilibrium is disturbed through financial developments. For example, we had many cases of hardship. I also had some cases of hardship in my arbitration practice after COVID. Yeah, it would have been possible to deliver the goods, but it was economically much harsher on the debtor to perform the contract than the parties had envisaged at the time of the conclusion of the contract. So it is now held that hardship is covered by the CISG, these change of economic circumstances. There are certain problems with bringing hardship under Article 79. The first problem is the relevant threshold. That means, when can we assume that performance of the contract is has become too burdensome for the debtor, so that we will exempt the debtor from liability for not performing the contract. So is it if the costs have doubled, is that enough that we can talk about of hardship? Or what is the relevant threshold for assuming hardship under the CISG? The other problem is what are the consequences of hardship? Because also in civil law jurisdictions, not in common law jurisdictions, but in civil law jurisdictions, there are different consequences for force majeure on the one hand, and for hardship on the other hand. In common law jurisdictions, both are treated the same way, and it is especially the CISG Advisory Council that has published an opinion on hardship under the CISG has come to the conclusion that we should not make a difference between force majeure and hardship, but rather have the same consequences for both impediments. This is different with UNIDROIT principles. They distinguish, like civil law jurisdictions, the UNIDROIT principles distinguish between force majeure on the one hand and hardship on the other, and have different consequences for force majeure and hardship. Again, as with regard to force majeure, it is advisable, and most contracts contain clauses regarding hardship. On the one hand, defining the threshold when hardship is present, and on the other hand, also dealing with the consequences of hardship. We still are discussing the prerequisites of Article 79.1. The first one we saw is an impediment beyond the control of the debtor. And second, this impediment must have been unforeseeable at the time of the conclusion of the contract. The standard, what is foreseeable, is that of a reasonable person in the shoes of the obligors. We have this standard in Article 8, para 2 of the CISG, where we have a rule for contract interpretation. But the reasonable person we find in many instances in the CISG, and we ask, what would a reasonable person in the shoes of the obligor, and that contains knowledge of the industry and so forth, what would such a reasonable person have foreseen at the time of the conclusion of the contract? The third criterion is that the impediment itself or its consequences have not been avoidable for the debtor. And there we have a lot of case law stating that there is a very strict standard. The debtor must try everything to overcome the impediment or its consequences. And even in cases where increased costs or where a loss is resulting for the debtor when overcoming the impediment, this has to be done by the debtor. Thus, it has to overcome the impediment, even if increased costs incurred or even if there is a resulting loss. Both criteria, the foreseeability issue and the avoidability issue, are heavily fact-driven. And that gives you ample possibility with this year's moot problem to discuss, because you have to find out all the facts be them for the claimant now as you are working on claimant's memorandum, or then once you are working for respondent's memorandum, that you find all the arguments, all the facts that speak for the party you are arguing for, that either the impediment was foreseeable or avoidable, or if you are arguing the side of respondent, that it was neither foreseeable nor avoidable. So just very, very briefly, the rest of Article 79, I already mentioned. Article 79.2 contains a rule for liability for third persons if the debtor has entrusted the performance of one of its obligations to a third party. This is not relevant in this year's moot problem. Article 79.3, temporary impediments, neither relevant for this year's moot problem. Article 79.4, CISG duty to inform the promisee. Well, there has been a question asked with this regard. Well, we will discuss it during the Q&A session. The duty to inform the promisee does not impact the possibility of being exempt from liability. It rather, if the duty to inform is breached by the obligor, then there may result a specific duty to pay damages, namely damages for the loss that could have been prevented by a timely information of the promisee of the impediment that is impeding performance. Article 79, para 5, the ISG is aiming at the consequences of exemption, and it makes clear that under Article 79, the debtor is exempted from paying damages, but that it's not exempted from relying on other remedies. There's also a question relating to this question, and other remedies especially are avoidance of the contract, also price reduction, and in most cases also specific performance of the contract. Finally, burden of proof under Article 79. The burden of proof is clearly dealt with under Article 79. If you look again at the wording, it says a party is not liable if he proves that the failure was due to an impediment. That means the burden of proof is on the debtor who wants to be exempt under Article 79. And this, by the way, is a general principle under the CISG, which we can develop from the wording of Article 79, para 1 of the CISG, namely that each party has to prove the facts on which it is relying for its own benefit, being for asserting a right or asserting an exemption like that under Article 79. Let's briefly go to the other possibility of exemption, Article 80. A party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. Well, the difference between Article 79 and Article 80 of the CISG lies in the consequences. Under Article 79, there's only an exemption from paying damages. And as we saw, according to Article 79, para 5 of the CISG, this exemption from paying damages does not relate to any other remedies. Whereas Article 80 is reaching much farther. Namely, under Article 80, if you look at it again, it says a party may not rely on a failure. That means under Article 80, all remedies are excluded in case of an act or omission of the promisee. There is discussion what happens if both parties have caused the breach of contract. Is Article 80 at all applicable? I think the now almost overwhelming view is yes, it's positive. Article 80 applies also in cases where both parties have caused the breach. In cases where we have monetary claims, like, for example, damages or the like, we can apportion the monetary claims according to the part of causation by both parties. And in case of other claims, I think we can act accordingly. We can also, for example, if the buyer wants to claim avoidance of the contract and has contributed 50% to the breach, then the buyer may only avoid if it pays 50% of the purchase price. So I think in that case, we can adjust the consequences under Article 80. Very briefly, Article 77. A party who relies on a breach of contract must take such measures as are reasonable in the circumstances to mitigate the loss, including loss of profit resulting from the breach. If he fails to take such measures, the party in breach may claim a reduction in the damages in the amount by which the loss should have been mitigated. This is mitigation of damages. And if we compare it to Article 79 and Article 80, under Article 77, we do have a breach of contract and we have liability in damages established. So there's no exemption once we come to Article 77. And then, only then, the aggrieved party must take all measures to prevent the loss or mitigate its extent. The sphere of application of Article 77 is, from the wording, rather clear. It relates to damages. There is discussion whether it can also apply as a general principle to other remedies, for example, to the remedy of specific performance or avoidance of the contract. Under Article 77, the obligee must take all reasonable measures to mitigate. This may include dealing with the contract breacher. There has been case law, for example, where the seller breached the contract and said, I will not deliver to the original contract price, but if you pay some additional money, then I will deliver the goods. So, and there is case law coming to the result that the buyer must strike a deal with a contract breaching seller and thus mitigate its loss and may not turn to the market where even higher prices are asked for. The consequences, if the duty to mitigate is breached, is that the amount in damages has to be reduced according to the amount that could have been mitigated by reasonable measures. So let me come to my conclusion. There are three different levels. The CISG deals with extrinsic circumstances that influence the breach or the extent of loss. The lowest threshold is the duty to mitigate. And if this duty to mitigate is breached, then it leads to a reduction of damages. The second one would be Article 79. If the extrinsic circumstances amount to an impediment beyond the control, then the debtor is not liable in damages. And the third level, finally, is where the breach is caused by the creditor, by the obligee itself, then the creditor has no remedies at all. So what we find here in the CISG is a well-balancing interests between the parties in these cases of extrinsic circumstances. And it has been argued, and I think rightly so, these three principles can be viewed as general principles under the CISG in the sense of Article 7, Para 2 CISG. And with this, I thank you very much for your attention.
Thank you very much to you, Professor Schwenzer, for this very interesting and enlightening presentation on the exemption grounds of this under the CISG. It's always a great pleasure to learn from a living CISG and Vis Moot legend like you. And even though I think the presentation was already quite comprehensive, I still have a couple of follow-up questions specifically on the exemption grounds and on the interpretation of the exemption grounds. So starting with the first question, you already mentioned in your presentation that not only these traditional typical natural occurrences like typhoons or hurricanes can consist of an impediment beyond the control of the parties, but also state interventions, or as you call them, faits du prince, can include or can consist of an impediment beyond the control of a party. But how can certain legal changes affect the performance by the buyer? And are they typically seen as an impediment beyond the control of the parties?
Yes, as I mentioned, there is diverging case law on these questions. I think the prevailing view is to treat state interventions and also, a change in the legal environment, just like other impediments. But if you are arguing now for the claimant, certainly it would be important to find, and there is case law, there are arbitral awards saying that this is not an impediment, so that there is no exemption from liability. And it would be important to find these cases and to argue along these cases for the case of claimant.
Thank you. Maybe moving on to a different topic, also a topic that you addressed already during your presentation, but maybe you could elaborate a bit more on the topic, specifically paragraph 4 of Article 79, which includes this notice requirement within reasonable time. So how have courts interpreted what a reasonable time is, and are parties perhaps sometimes even excused to notify the other party?
Well, the term reasonable, the interpretation of the term reasonable throughout the CISG is heavily fact-driven. So it depends on the circumstances of the specific case. For example, on the question whether we are dealing in a volatile market, yeah, and the duty to notify the obligee of an impediment serves the purpose that the obligee, for example, if the seller is exempt, then the buyer might turn to the market and make a cover purchase. Yeah, and to give the buyer or to the other party the possibility to make such a cover contract, and whether this must be very within a short time is depending on the market concerned, and other circumstances that might be taken into account is whether the debtor needs time to ascertain how long will the impediment be present. Yeah, will it be a temporary impediment, or will it be a longer impediment, really affecting the whole contract? In case where there is a final impediment, yeah, it will also depend. Does the other party know about the impediment? Yeah, that is a question where we can also rely on Article 40, because we do have a notice requirement in case of non-conformity of the goods. In Article 38 and 39, the buyer must give notice of any non-conformity that could be discovered under Article 38. And if it does not give notice, it loses all remedies for non-conformity of the goods. But Article 40, the seller is not entitled to rely on the provisions of Article 38 and 39 if the lack of conformity relates to facts of which he knew or could not have been unaware. So if the other party knows about the impediment, there is no reason to give notice under Article 79, Paragraph 4. And what I want to emphasize is if the aggrieved party does not give notice, the debtor affected by the impediment, if it does not give notice, this does not affect the exemption under Article 79. Yeah, exemption is still possible. The only consequence is that the debtor is liable in damages, liable for the loss that could have been prevented if the notice would have been given within a reasonable time after knowledge of the impediment. So that is very important. It's not affecting the exemption as such. It's only a separate duty to give notice with a separate liability in damages for the loss that was incurred because the notice was not timely given.
That's well understood. So not an exception, but a recalculation of the damages essentially if the notice is too late. Turning maybe back to the main paragraph or the main provision under Article 79. So the first paragraph, as you mentioned, the impediment must be both unforeseeable and unavoidable to fall within the scope of this provision. So let's maybe focus on both of these separate requirements, so the unforeseeability and the unavoidability of the impediment. So starting with the unforeseeability, so how exactly do courts determine whether an impediment was foreseeable or unforeseeable? You mentioned the standard of the reasonable person, but do courts also consider certain specific industry specific risks? How do tribunals and also consider certain changes in prices, spikes in prices or sanctions in evaluating whether a certain impediment was foreseeable or not?
Yes, certainly. I mean, it's also very, very fact specific. And in practice, we would very often ask an expert whether something was foreseeable in the industry, whether the occurrence of floodings or of a typhoon was foreseeable in that region, or whether a fluctuation of prices was foreseeable or not. I had a case myself as an arbitrator where there were where it was argued that in the 1990s there was already such a fluctuation of prices, so it was foreseeable and the parties could have provided for in their contract for such a fluctuation of prices and its consequences. So it's very, very fact specific. And usually we would have to rely on an expert to help us what is foreseeable for a reasonable person in the same circumstances.
Well, unfortunately,
And the same for avoidability. Yeah.
Well, unfortunately, the students, when drafting their memorandum, will not be able to rely on an expert, so they'll have to be their own experts. But I'm sure after this presentation, everyone will be an expert on the exemption grounds, at least the legal.
Yeah, I would suggest that the students go back to the problem and really find each and every fact that is pro-claimant or pro-respondent, and so they have to gather them all, and then it's easy to argue the case.
That's great advice. Thank you, Professor Schwenzer. Maybe moving on. So we just discussed the unforeseeability. Let's maybe move then to the second criterion under the first paragraph, that the impediment should also be unavoidable. So here, similarly, courts take into account specific facts to determine whether a specific impediment was indeed unavoidable. But maybe focusing on a specific scenario. So if a party could have obtained an alternative source of supply, could this impediment then also still qualify as unavoidable?
Well, it depends how difficult it is to find this different source of supply. Yeah. And well, there is case law that very much is asked for from the debtor. It has to incur more costs, for example, and even to the point where the whole transaction is resulting in a loss for the debtor, it may not be exempted under Article 79. So here it is important for the students. Also, I looked at the PO number 2, and there are hints how much burdensome any alternatives would have been for respondents. So you have to find out these alternatives and discuss them, and discuss for claimant why they would have been feasible, and for respondent why this was not to be expected from respondent.
I'm sure many students watching are now going straight to PO2 to find these cues there. I think we have time for a final question to you, Professor Schwenzer. So maybe a more general question on Article 79. As we know, there is no general overarching court overlooking the CISG. So there are always the national courts that need to interpret the provisions of the CISG. Would you say that Article 79 has been interpreted by courts across jurisdictions in a uniform way, or are there considerable differences between legal systems?
Well, there are certainly differences, and that is a problem that we face throughout the CISG. And that is why, and I think most of the students know it by now, the CISG Advisory Council has been created. And we are now working since more than 20 years, and we have published something like 23 opinions in areas where there has been diverging case law. And actually, we have published 2 opinions on Article 79. The first one was already something like 15 years ago, or even more than that, on the general application of Article 79, and more recently, about 3 years ago or so, or maybe 4 years ago, on hardship under Article 79. And the opinions published by the CISG AC do not have any binding character on courts, but they are cited around the world by Supreme Courts around the world as persuasive authority. And especially, and I was this year in July, I gave a presentation in Beijing at a conference, and there were Chinese colleagues who gave presentations and who told me that Chinese courts are more and more relying on the opinions of the CISG Advisory Council to guide their decisions. And also the German Supreme Court, Dutch courts, and also American courts have relied on the CISG Advisory Council opinions as persuasive authority, and thus there is the possibility to bring some more, let's say, uniformity in the application of the CISG.
Thank you very much from my side, Professor Schwenzer, for this wonderful presentation, and also for this very engaging Q&A session. I would like to hand the floor back to my colleague now, Erin.
Thank you very much. It was my pleasure.
Thank you.
Well, thank you. A huge, huge thank you indeed to you, Professor Schwenzer, for sharing such clear and valuable perspectives, to Warren and to all of you in the audience, whether watching live or in the recording, for indeed being part of this very important conversation in different ways. And of course, a very huge thank you also to our partner, the Arbitration Channel, for hosting this conversation. Also very, very important. Overall, this collective engagement is what makes all of these sessions very meaningful. So for those who are observing and who are still stuck in the midst of their claimant's memo and soon to be the respondent's memo too, I encourage you to carry today's insights into your preparations and think about how you can structure persuasive arguments, how you can incorporate the many tips that Professor Schwenzer has shared. I will leave you to the recording to scrutinize and pick up exactly what those tips were. And also, very importantly, how you can anticipate the questions that a tribunal will be asking you in the near future. And remember, you have heard it here from the mouth of Professor Schwenzer. All you have to do is look at the facts, and then your arguments will be easy. Famous last words, potentially. I'm sure that there will be people coming up to you in Vienna and Hong Kong, Professor, and giving you their feedback on that advice in due course. And of course, well, the CISG is only one component of the Vis Moot problem, but there are many, many others, procedural, legal research techniques, and legal writing as well. So coming up next, we at Africa in the Moot will have 3 sessions. The one is on the CIAC rules, that is happening tomorrow, and that will be about the interaction of the CIAC rules and the Vis Moot problem. On the 5th of December, we will have a presentation by Jusmundi on legal research techniques. And then on the 17th of December, there will be a session for legal writing as a respondent with that focus. Also very important, as you will have submitted your claimant's memo by then. So please stay tuned and follow Africa in the Moot for further details. You can find information on the QR code there, or of course through our LinkedIn and other social media. And finally, Africa in the Moot really relies on the support of its volunteers and its partners in different forms to be able to fulfill its mission. So please do consider supporting us via the QR code that is available on the screen now. And if you have any questions or any ideas of how you think that we can make our mission better and stronger, please do reach out to us via social media or email at info@africainthemoot.com. So with that, I want to thank everybody once again, and I wish you the very, very best in your continued Vis Moot journey, and have a good whatever time of day you happen to be in right now.